Welcome to the class of Conveyancing and Legal Writings, Law 401, Section 1, Week 5, Part 1. We are going to start this video with affidavit. First question is, what is affidavit? An affidavit is a voluntary, sworn statement made under oath, used as verification for various purposes. The statement is witnessed and signed by a notary public or other law official authorized to do so. Once signed, the document is legally binding, and the person signing is subject to being charged with perjury if the affidavit contains false information. To explore this concept, consider the following affidavit definition. Those are: number one, affidavits are a sworn statement. That means a legal document containing facts that are relevant to a legal proceedings. Number two, a statement that is written and confirmed by oath or affirmation. Number three, a written document that is signed by a person who confirms that the information included in the document is accurate to the best of their knowledge. For example, Jack has a sister who lived in New York. She recently passed and left behind a huge sum of money, along with a house in the country. He finds out That means Jack finds out other family members are claiming that they are the closest of kin and are the rightful owner to the assets. Jack contacts his lawyer and creates an affidavit stating that in fact he is the closest kin because he is the only brother of the deceased. Therefore, an affidavit is a type of verified statement or showing, or in other words, it contains a verification, which means it is made under oath or penalty of perjury for false information or falsehood, and this serves as evidence for its truth and is required in court proceedings. Next question is, why are affidavits important? If you do have any legal works, then it is imperative for you to get a legal affidavit form. In the legal terms, the affidavit is a legal document that enables a person to take declaration under oath. There are several types of affidavit used by the person for different works. The declaration of the person is perfectly legal and has the full authority which is acceptable in any requirements in the court proceedings. Therefore, it can explain two ways. First, the truth of the statement is established through an affidavit. Being a necessary legal instrument, it authorizes and helps in establishing the truth of the declaration about any matter. The person uses this affidavit for supporting their statements or any other documents. After the statement of any fact is featured on the legal document, it is signed by the person who is declaring any matter legally. This declaration and signing process is witnessed by the public notary in general. Second, basic details required making a proper formatted affidavit. There are some basic details that are furnished in the affidavit, which are: the affidavit forms must be descriptive and clear in approach. The affidavit must contain the deponent's name, address, location, and even contact number must be included. After drafting the document in proper format, it is signed by witnesses and by the deponent himself or herself with the specified date. Next question is, whether can it use as evidence? As I already mentioned, the affidavit is a statement of facts. It should set out observation without color or comments and refers to the factors a court must consider before making an order with signature. Therefore, it can say that affidavit becomes evidence in a specific case. According to the law of Bangladesh, an affidavit is used as evidence, and from there you cannot retrieve yourself as you want. This doctrine is known as doctrine of estoppel, which is presented under Section 115 of the Evidence Act 1872. That means affidavit creates a bar from denying or confirming a certain fact owing to that party's previous conduct, allegation, or denial, and try to prevent injustice owing to inconsistency or fraud. Similarly, if your affidavit is proven wrong with malafide, that is bad intention, you could be charged under section 139 you could be charged under section 193 of the Penal Code 1860, where punishment for false evidence is stated. You may be imprisoned up to 3 years with fine for non-judicial use of an affidavit. In the matter of judicial use, it could be up to 7 years of imprisonment. In this slide, I am going to give a format for an affidavit. For a format, you have to write the name of the affidavit, that is declaration for change of name affidavit. Then you have to write down your new name, that is Michael Anthony, son of Chandra Das, at his age, address, everything. And then that my name earlier was Kiran Das. Kiran Das was Michael's earlier name. You have to mention it. That I have changed my name on Michael Anthony on from 1st January. So when he changed his name, you have to mention that date also. Next, you will mention that whether it is recorded or not. At present, all the records have my new name, that is Michael Anthony, but I have not published. If you already published that, so that then you need not to indicate that. If you have not published, then you can indicate I have not published in the Gazette for change of name. I state that Kiran Das earlier name and the Michael Anthony present name is the name of the same person. So you have it is your truth that, and you confirm that it is the true or accurate information. Then you said that I am executing this declaration to be submitted to the concerned authority for the change of name. So you change in a proper manner. You also confirm that. I hereby state that whatever is stated herein above are true to the best of my knowledge. That means you have no false intention, or you have no you did not include any false information. So you confirm that all the information included here, those are correct and true. This is the last part, that is the formalities of the affidavit. Before we are going to this part, please remember the affidavit should be typed double space line and 12-point font and printed clearly on only one side of the page. The content of the affidavit should be divided into paragraphs that are numbered. It is a good idea to divide an affidavit into sections under separate headings. If you have any different headings, then you can give different separate headings. For example, the headings might be arrangement for the children after separation, or property given under during the marriage. Each paragraph should, if possible, cover one topic or subject matter. Next part is formalities. For formalities, you already know there is a testimonium. Here, the testimonium is that the deponents who signed in my presence before me is known to me and identified by me, and that me is advocate. So the person making an affidavit, the deponent, must sign the bottom of each page, obviously bottom of the page, in the presence of the authorized person, that is a lawyer or advocate. On the last page of the affidavit, the following details must be set out: the full name of the person making the affidavit and their signature, whether the affidavit is sworn or affirmed, that is confirmed. I already wrote down here solemnly affirmed at address, an address of advocate. The day and place the person signs the affidavit, that is the address and date I already mentioned here. The full name and occupation of the authorized person and their signature. So authorized person is advocate, or you can also say that the authorized person is notary public, who made the notary public. He can be an authorized person. Um, and you should remember that affidavit should be attested by notary public. If you looked at any notary public, then you can check there is a red mark and which shows that specific affidavit attested by notary public. And that's all the format of affidavits.